Welcome back, everyone, to a new episode of the Jon Gil Podcast Show. And I'm super excited to have on today Michael Bradley, attorney at law. He's been an attorney since the 80s, practicing criminal and divorce cases, real estate-related cases. Prior to that, he was also an administrative law judge. And really, since 2004, he's been handling real estate-related cases, more specifically probate. And on this episode, we're excited to have him share with us the probate process and the way that works. So again, as always, if you like what you hear, hit like, and please, if you can, subscribe to the channel. That'd be greatly appreciated. So without further ado, Michael Bradley, how are you?
Fine, thank you.
Awesome.
Thank you for having me.
Yeah, thank you so much for being on the show. I really appreciate you being here. And Michael or Mike?
Either one is fine.
Either one is fine.
Yeah.
Okay, perfect. So, can you tell us a little bit about how you got involved in the in law and some of the? Well, let's start with that first.
Well, I was a philosophy major,
Okay.
so the choices afterwards were either obtain a PhD and pray for your employment somewhere, or law school involved. I thought a wider variety of avenues, and I did want to stay in the Chicago area.
Okay.
As you can imagine, getting a PhD, you're pretty much subject to whoever extends you the offer.
Correct.
So I wanted to stay in Chicago. I thought practicing or getting a law degree would help me do that.
That's amazing. And how was that? How was the start? Once you got your law degree, can you tell us a little bit about how that was, getting your clients, getting the momentum going?
I came out in not the best time, and it's funny how things go full circle.
Mm-hmm.
I started on my own not too long after law school, and what I did was I said I have to do something different to attract clients, and I advertised then in the Sun-Times. People actually read the newspaper to get their professionals, and I advertised we make house calls. So I was attracted to many people who either didn't want to go downtown. Back then, there weren't as many. Most offices were downtown. There weren't as many lawyers in the neighborhoods as we have today. But that I attracted a clientele that way. I was doing something that nobody else was doing, so to speak.
That's amazing. And actually, that form of advertising still works today. Do you even rely on that now, or is it mainly just referrals and kind of just word of mouth for business?
The referrals is where I get most of my business. However, I do like going to the client's house.
Okay.
Many times the client's more relaxed there. Many times it's very inconvenient for them to leave.
Mm-hmm.
Although now, of course, people are doing more things with the email, so they don't want to leave their home for any reason.
Of course. Yeah, it's interesting times, to say the least. So explain to us a little bit about the transition from, because it seems like you were doing criminal and divorce cases, you were an administrative law judge, and then you started to focus heavily around 2004 in real estate. Can you explain that transition?
Yes, my wife and I own an investment property, so we understand what investors go through, having done it ourselves.
Sure.
And doing it ourselves.
Yeah.
And just with the clients we had, we like to be available for them and for whatever they need, whether it's to draw up a will, whether it's to evict a tenant, whether it's estate planning, or
Clients
whether it's
too.
the actual closing of a real estate deal.
Okay, so that makes sense. It was just a smooth transition. And, now getting into the actual probate, can you explain what probate is?
Yes. Probate essentially involves what your estate owns, or what you own, so to speak, the moment after your death.
Okay.
Certain items you lose ownership interest at your passing. The most common being, say, a joint tenancy deed. Husband and wife own property in joint tenancy.
Mm-hmm.
Husband dies, the property automatically goes to the wife in joint tenancy. It does not matter what his will says. If his will says I leave half the property to my wife and half to the children,
Mm-hmm.
it doesn't matter. It operates automatically the moment of his passing. Excuse me, I'm going to adjust these here.
Yeah, no problem.
So life insurance policies operate the same way. The moment of someone's passing, the designated beneficiary has a vested interest in the property. What probate involves is what you own the moment after your death, so to speak.
I understand. And so that makes sense. Now, can you explain why it is that every time I see a real estate related listing, or if I see a listing for real estate that has to do with probate, the process is just so long and drawn out in the courts? Is that just poor planning, or what is that attributed to?
It can be. Often the people don't get along very well. I used to joke and say in my family, one person dies and two people never speak again. But many times the people just don't get along, and some of that can be avoided with the testator designating what he or she really wants and expects, and appointing the person as the executor who will carry out those wishes. Letting them know where the will is. Many times they don't even know there is a will, or they search for a will, and things have been going on right after the decedent's passing, and then they might find out later, a month later, there was a will, and by the way, he wanted to be buried in this cemetery, or cremated and not over there. So a lot of times the decedent really could be more organized, and that, I think, it starts there. A properly organized will that people know about, I think that sets the stage for a smoother transition. Oftentimes there is no will. People end up in probate court. Then there's disputes between family members. Some like to say, I want to keep the property in the family. That's great for the one heir who lives there. It's not so great oftentimes for the two that are out of town and would like some of the proceeds of that, to cash in their equity, so to speak. So there can be a lot of fighting or disagreements back and forth.
That makes sense. So who has the legal priority? Is it the wife? Is it the children? Is it if he's not married or didn't have kids, is it the sibling? What's the order of priority?
It'd be next of kin.
So,
I mean, if you don't leave a will, it would basically the legislature writes you a will, and in a sense sets up a system of laws where your next of kin has the preference in nominating an executor, or an administrator. Without a will, it would be an administrator.
I understand. And if they can't find next of kin, does it just revert back to the state, the assets, and just get sold off?
No, if you never can find anyone, you're correct. That would happen. That's pretty rare, though. Usually there's a cousin or somebody, or a third cousin. Someone will be around. There's not much property that is cheats back to the state.
Got it. Okay. Well, that's interesting. Now, so you help with the planning, and what sort of how does the planning process look like? Can you walk us through it? Someone reaches you and says, Mike, I'm looking to set up my will, because you really don't have to be on your deathbed to start thinking about these things. I mean, this is something that really because death is unexpected. It can happen obviously at any point in time. It's something that we all should be talking about and probably should do.
You're right. And on your deathbed is probably not the best time to be doing these things. You have other things of more immediate concern. But yes, I would say with a significant change in lifestyle, for example, even if there's a will in place, when there's a change, like, for example, husband and wife, more likely it's the husband who will die, but then the wife ought to really look at that will much more carefully. Probably the first will, everything goes to the spouse, but now once the survivor is left, they ought to really focus in, and as they're aging, what do I want, and how do I want to achieve it? And also, they can decide. There's also people want to avoid probate, to avoid some of the skirmishes you referred to, by setting up revocable trusts where they place their real estate in a trust, and then they appoint a successor trustee. So at their passing, the successor trustee takes over and they can list it with a realtor as yourself or someone else who can then more easily sell the property.
Understood. Huh. Interesting. So, again, just walking us through the process. They reach out to you. You have a formal kind of document that they need to. Is it just you just run the different ideas with them? Can you walk us through that process?
Good question. Yes, you want to find out what are their concerns. Well, what are their assets first of all? We want to make sure that they know what they are and that they know the difference between a joint tenancy property and property that's just in their own name. And I always make sure they know. Most people know, but occasionally there's some mistake that certain property will revert automatically to the surviving joint tenant, regardless of what your will says. So and that also can be on bank accounts. Mm-hmm. So be a little cautious on how you have your bank account set up. You may be listing or wanting to leave everything, say, to your brother, only to find out that you would set up the bank account with a survivor, someone has surviving rights, and then they become the owner of that bank account. So we want to make sure they know what property they have and in what form they're holding it, because as we just went over, that can make a big difference. And then we go over who do they want to leave the property to. I've been surprised. I've asked a number of times, do they want to leave it to a charity or, include a charity, not to leave it to the charity.
Right.
But they're pretty much, they want it to their, the children, next of kin. Right. Rarely do they say, I want 10% to go to the Red Cross or something like that.
Okay. You never hear the, half to my wife and half to my girlfriend. Because okay. Well, you never know. I'm sure you hear some things. So the other thing I want to point out is,
I think the girlfriend would be taken care of during life. I think if she expects anything afterwards, I think it's not likely to happen.
Yeah, it's not right, exactly. So, okay, that's great. Now, again, going back to probate court, can you explain that process and how easy or explain the fees involved, I guess, with probate court?
Yes, in probate court, one of the key features is notice to relevant parties. So, for example, there's a will filed. Well, the will may be different from what the intestate succession would have been without the will. So, for example, if the surviving mother wants to give more than half her property to one child, say 60% to one, 40% to the other, just to make a hypothetical, or just not include one. Well, but for that will, there would have been a 50-50 split, assuming two children.
I see.
So you have to give the heirs notice. Anyone who would have taken but for the will has to be served a copy of the paper so that they know there's a will out there and they can find out what their representation is or what their inclusion is in the will. If there is no will and someone is filing to be an administrator, which will give them the ability to sell property without court permission or without the permission of the other heirs, they will petition the court, serve notice on all the other heirs that they want to be the administrator. And then the court will have a hearing. Normally it's uncontested, but there could be a contest. But in general, there's a 30-day notice period that people must have in order to decide if they want to contest this or whatnot.
And I assume that process may look differently in other states, right? Is this?
Yes, probate is, and I don't profess to say what will happen in other states. I've noticed real estate in general is different. Even outside Cook County, there can be different practices. But maybe the laws are probably the same, but how it's administered in different states. And then, of course, if it's a community property state or then other things can take effect. In Illinois, there's the surviving spouse receives $20,000 of the estate automatically. So that could be different in different states.
Oh, interesting. Okay. Wow. That's good to know. The other thing that I wanted to point out was you mentioned earlier that if someone writes their own will, it may not hold in court, correct?
Yes, I'm amazed. I just had one recently when this was a person of some means and who decided to write up their own will.
Okay.
And it's not that hard to do, but there's a few things that must be done. And if they're not done, could be a problem getting it as it being a valid will. So basically, you just have to state what you want. It must be witnessed by two people who are not a beneficiary of the will. So if you leave everything to your brother, it won't count if your brother is a witness to the will.
Understood.
So, and it's preferably notarized, so that way it obviates the need of the witnesses to submit an affidavit or come to court. So it's really not hard to draw the will, but there are a few rules. The witnesses must say that they watched the testator sign, that the testator signed in their presence, and they witnessed in the testator's presence. Small things like that. But if they're not there, that can the will may be declared invalid, and then it would go to intestate succession as if there was no will.
Wow, that's incredible. So you mentioned that the witnesses have to be present. If they get their will notarized at a currency exchange, that I highly doubt that person's going to want to show up to court and prove, right, that they were a witness.
Right. Well, now, most currency exchanges are smart enough to know that they don't want to get involved in the legal process, so they're not likely to notarize a will because they could then be called, that dollar fee or whatever may be their ticket to testifying in court as to if there's any claim of coercion, duress, etc. They don't want to be involved with that. But yeah, basically they would many times either the lawyer, like I'm a notary public, or secretary in a law firm is a notary public. So it's signed and witnessed in the lawyer's office in front of a notary. That's the standard way it would happen.
Perfect. So now anyone looking to hearing this today that wants to take advantage and just get organized and get their will going, it seems like, will you still meet them at their home, or can they meet you at your office?
Yes, I often meet them at their residence.
At the residence.
And then we talk over. Okay. And there may be other things they need, such as a power of attorney for health care. I usually don't push that if they're younger, but if they're older, then it's something to consider that's more popular now. Before we had living wills, which are still statutory and effective, but that's more between, you're giving the physician some discretion. Most people now want to give it to a person they appoint.
Got it.
So that's where a power of attorney for healthcare would come in.
Yeah, let's dive deeper into both of those. Explain the living will.
A living will is basically you're giving the physician some discretion as to.
So you're on your deathbed, probably.
Yeah, exactly. Okay. Yeah, you may in a coma, and then there's certain life-saving techniques or remedies they can attempt. Now, that would not include denying food or water, but it would involve certain things in the person in a coma. They may just not do if they feel that the person has an irreversible coma. And I think a lot of physicians would prefer that a next of kin or family member have that responsibility. So people give people a power of attorney for health care, which is less important if there is a spouse on the scene. But I just had a situation where a friend of mine, she had no spouse, no children. Well, the last thing that a nursing home who's providing intensive care wants to find out is that different people are giving different instructions. So it really helps the nursing home or the doctor when one person is the one who's and she did have that. So that worked out well. But that's who they want to see, and it's vital if the person doesn't have a close next of kin that the physician or nursing home would turn to.
Understood. And I know it seems that most people would know this, but can you explain what a power of attorney is?
A power of attorney, yes, and I'll tell you what it's not. It does not survive your passing.
Okay.
So if someone says, I'll see that a lot where they'll come in, the person's deceased, and say, I'm the power of attorney, and I have to explain, well, that ended when the person died. Wow. So that's where the will takes over. Okay. The will doesn't have any effect during your lifetime, but it does after your passing. The power of attorney ends at death. Okay.
Interesting. But I never knew that.
So it allows the person to basically act in your stead during your lifetime. And it can be for simple things where you're going out of town and you want to designate someone, even though you're in good health, fine mental faculties, etc. It's just inconvenient for you to take care of certain business in a certain town around a certain date, and you can appoint somebody. Many times in real estate closings, as I'm sure you've seen, the seller does not want to be at the closing, right, and they've given the attorney power of attorney to act in their stead, to sign documents, the closing statement, sign the 1099 form to the IRS, etc.
And are you still handling regular real estate transactions?
Yes.
In addition to, okay, so that's great to know. Michael, if anyone wants to get a hold of you, what is the best way for them to reach you?
I'd say now the email would be the best at mwbradley, BRADLEY, 89 at yahoo.com.
Perfect. Michael, this has been great. You've been, I think right after this, we may want to just go ahead and start preparing my own. I mean, with everything going on nowadays. But anyway, this has been great. Is there any last thoughts or any other thing that we haven't discussed that you may want to kind of bring up here in closing?
No, I would just advise the public to think things through. Think how things will be 5 years down the line, or what will happen after your passing if the person is elderly, or if they know someone who is elderly. Say, you don't really want to think about things when you're going through a health crisis in the hospital. That's not the time when you have the clearest thought. So the sooner you start to think about these things and take some steps, the better.
Fantastic. Well, Michael, it's been great.
Thank you.
And again, if you want to get a hold of Michael Bradley, go ahead and send him an email. And we're going to go ahead and place that link here as well on how to get a hold of him. So if you like what you heard, as always, hit that like button, subscribe to the channel, and we'll see you in the next episode.